In this PowerPoint, we want to look at federalism. Actually very simple word to understand. But the problem is that in American history, we have used this word in many different contexts. We've used it as the name of a political party. We often say federal government, which creates a little confusion. Um, and So what we're going to try to do today with this PowerPoint is help us to have an understanding of the word and how critical it is. We've talked about the Constitution, the executive branch, the legislative branch, and now we want to look at kind of what holds um, the states within the United States together. What is that relationship between the states and the United States? And that is defined by this word, federalism. So in this PowerPoint, we're going to define the word. We're going to talk about how power is divided in our federal system. We're going to talk about horizontal federalism, a very important court case, the McCulloch, Maryland case that has to do with the national bank, that is a state national issue, and then an amendment that's critical to this conversation that really changed the conversation between the states and the United States in a very, very important way. And then we're going to talk about two areas that the 14th Amendment affected in our daily lives, the rights of the accused and the right of privacy. First of all, federalism defined. There are three types of government. There's what we call unitary government. That's a government in which power is centralized in one place. There's confederal government. That's the opposite of unitary government. In a confederal government, power is regionalized and there is no central government. In a federal government, the power is divided between central and regional governments. So in the United States, we have a central government located in Washington, D.C., but we also have 50 states, and each one of those states has a government of their own. So we have what's called a federal system, because the power is divided between the central government, which we unfortunately often refer to as the federal government, and regional governments. In federalism, the power is divided between regional and the central government. And there's a list of these are just kind of definitions, words that we want to understand the way power is divided. First of all, powers that are delegated are the powers that are given to the national government. We've talked a little bit about that already. Powers that are denied are powers that are actually denied to the states. That's in Article 1, Section 10. The examples of these types of powers that the states are not allowed to have. States are not allowed to make treaties, to coin money, to put taxes on trade coming in and out of their state, or to declare war. Imagine if Utah could make a treaty with Mexico, or go to war with Mexico, or coin their own money, or charge people to sell things, to move things through Utah. You can't do those things. These are powers denied to the states. You can find the list in Article 1, Section 10 of your Constitution. Reserve powers are powers that are reserved to the states. That's in Amendment number 10 in the Bill of Rights. An example of that would be police power. The states have to enforce their own laws. The simple laws that exist in your neighborhood. If someone breaks into your home, the federal government, the national government, is not going to come and arrest people. It's going to be your local. You have state police and local police. Concurrent powers are powers that are shared between regional and national governments. And good examples would be taxation. States can tax, the national government can tax. Borrowing money, establishing courts. These are powers that are shared or concurrent. And then the national government has certain powers in relation to the states, and some of this might actually be responsibilities, but examples of this is that only the national government can admit new states. They are the ones that have control over national lands. So in many states there are areas of the state which are controlled by the federal government because they are national lands. They have to guarantee that they will provide a republican government. They have to protect states from invasion and from internal violence. It kind of goes back to some of the things we talked about with regard to the economic issues and Shays' Rebellion that spurred us to write the Constitution in 1787 in the first place. Horizontal federalism. We're going to look at some definitions here. The first one is the full faith and credit clause. Um, this means that each state has to give full faith and credit to every other state's public acts, records, and judicial proceedings. In other words, one state can't ignore the laws or records or proceedings of another state. They have to recognize them as official. And there are many applications of this. Horizontal federalism also guarantees you all the privileges and immunities of citizens of any state. So each state has to extend to every other state's citizens the privileges and immunities of its own citizens. So, for example, if you're traveling to another state, and say you're in Delaware or Maryland, and something happens there, those states have to extend to you as an American citizen all the rights and privileges and immunities that they extend to their own citizens. Then interstate extradition. Each state has to agree to render persons who are fleeing from justice in another state back to that state. You can't break a law in Pennsylvania and flee to Maryland and uh, be be harbored there or be protected there. You have to, under our federal system, you must allow extradition. So there's some horizontal federalism, and this is relationship state to state within our system. How do they relate? They have to give full faith and credit to each other's records and acts and proceedings. They have to give privileges and immunities to their citizens, and they have to extradite criminals. Big court case involving the issue of state national relations is McCulloch versus Maryland. This involves a national bank. You'll remember Jefferson's opposition to the national bank. Well, he lost that argument, and a national bank was created. And later on, a few decades later, um, there was this question because the state of Maryland decided that the national bank, that was a branch of the national bank, was operating in the state of Maryland. They decided that they were going to start taxing the national bank that was operating in the state of Maryland, just like they might tax anything else. It was inside of their state boundaries, and they thought, well, we're going to tax it. And so this raises a very important question between national power and state power. And the Supreme Court took a look. McCulloch versus Maryland. Daniel McCulloch was the branch manager of this bank, and he sued the state of Maryland on behalf of the United States government, saying, you can't tax us. So the court looked at this, and the Supreme Court said that Maryland could not tax the bank. They sided with the government of the United States, and they said that the bank was constitutional, first of all, based on the necessary and proper clause. Remember Jefferson saying it was convenient but not necessary. Well, the Supreme Court disagreed. They said it was necessary and proper. And the Constitution, they said, was created by the people, not the states. You remember, if you've been paying close attention, that the ratification of the Constitution was done through state conventions, not through state governments. And so in this ruling, the Supreme Court said, well, the Constitution was created by the people and not the states. And so if we allowed a state to tax the national bank, it's like an indirect tax on all of the people of the entire nation, because the national bank is a constitutional entity and the Constitution was created by the people of this country. And so they said you cannot tax it. So that was their reasoning. This is a very, very important ruling, establishing some additional power to the national government and solidifying some things that have been in question previously. The other very far-reaching um, thing that's happened to change the relationship between the states and the national government is far beyond what the original Constitution stated. Was what we call the nationalizing or the nationalization of the Bill of Rights through passage of the 14th Amendment. And we want to start by understanding this, and I'll just remind you of this. We're going to talk more about the Bill of Rights later in the course, but the first 10 amendments to the Constitution, the Bill of Rights, were added immediately following the writing of the Constitution because many people said they wanted a guarantee of rights, that the things that the national government could not do because the Constitution said what it could do, but they wanted some very specific things stated that kind of protected us from a national government growing too powerful. And so the Bill of Rights begins with Amendment 1, which is the most well known of the amendments in the Bill of Rights. And the words, the first five words of that amendment are Congress shall make no law, dot, dot, dot. And it has to do with freedom of speech and freedom of religion, etc. But Congress shall make no law. The amendment, the First Amendment and the Bill of Rights was written to restrict the national government. This had nothing to do with the state. It guaranteed that the national government cannot take away your freedom of speech, your freedom of religion, your freedom to assemble, freedom of the press. It did not guarantee any American that the state could not do those things to them. It had nothing to do with the states. The national government had nothing to do with that question. This was a very specific set of restrictions on national power. That's very important to understand. Then we get to the 1860s. Civil War had come to an end, and we had just freed the slaves as a result of the Civil War with the 13th Amendment. And we decided to pass an amendment to the Constitution, number 14, which would guarantee people rights in this country. The fear was that Southerners, when the war was over, that white Southerners would begin systematically denying freed slaves their rights. And so the 14th Amendment was written. And in that context, you can understand these words. I'm just going to read them off the screen here. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That essentially made all freed slaves citizens and of the state wherein they reside. So this first sentence makes all freed slaves citizens of the United States and also makes them citizens of the state that they live in. So South Carolina couldn't say, well, you're a citizen of the United States, but you're not a citizen of South Carolina. This amendment made that impossible. That was illegal to do now. No state, then in the second sentence, shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So you can't pass a law now that is against the immunities or protections of citizens, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, these last several statements here are really important. They all can be drawn into one context. What this does is it says that the state governments now are restricted by the Bill of Rights the same way that the national government is restricted by the Bill of Rights. They can't come in and take away your freedom of speech, your right to own a gun, your freedom of the press, or your right to assemble peaceably, freedom of religion. They can't take those things away from you. The states can't take it away from you now. Now, here's the deal. So this is the nationalization of the Bill of Rights. This is taking the Bill of Rights, which was a simple restriction on the national government, and applying it across the board to all states so that there's No one in America, no government in America can deny you these basic rights. And you say, well, that's a good thing. And certainly for freed slaves, it was a good thing. And I am absolutely not arguing that point. I would agree completely it was a good thing. But here's where, and I think one of the things we have to understand when we talk about government and politics, there are good things that are also bad things. And that's when I think we get confused and get frustrated in our conversations with each other. There are good things that also have bad outcomes to them. And here's the bad outcome, in my view. And maybe you would disagree, which is absolutely fine. But the bad outcome is now somebody has to be in charge of making sure our rights are protected. And what's happened is that the national government now, instead of being restricted by the Bill of Rights, now is going to come into your state and my state and enforce the Bill of Rights. Make sure that the state of Pennsylvania is not violating anybody's rights. And whether you like that idea or not, the truth is it is a completely different rule than the Constitution, than the founding fathers under the Constitution established for the national government. They did not see this or desire this in any way. These were things that were to be worked out within the states. And so we have what's called the nationalization of the Bill of Rights through the passage of the 14th Amendment in the 1860s. And as you can see, just to break this down a little bit, so states can't deny state citizenship to U.S. citizens living there. They can't pass laws that abridge privileges and immunities of U.S. citizens. They can't deny any person life, liberty, or property without due process, and they can't deny anybody equal protection of the laws. Summary of this: the nationalized the Bill of Rights. The national government now is the protector of these rights, which is the opposite of the original purpose of the Bill of Rights. I want to look at an area in which how does this come into our lives, practically speaking? Well, one area is the rights of the accused. Previously, as we know, the police power was a power that the states held, wasn't delegated to the United States. But since the 14th Amendment, a number of cases, rulings by the national government, by the Supreme Court, have dabbled in this area. So in Gideon versus Wainwright, the Supreme Court said that you have a right to an attorney in state cases, not just in national cases, but every person has a right to an attorney. In Miranda versus Arizona, the Supreme Court ruled that protected people against coerced confessions. This is the Miranda ruling in which people have to Mirandize, police have to Mirandize prisoners, people that they arrest, and tell them what their rights are so that they can then get an attorney or do whatever else is protected, not speak or whatever. So Miranda versus Arizona, the government got involved in that. In Monroe versus Pope, the national government, the Supreme Court said that a citizen has the right to sue the police. So they created a huge opening there. Again, nationally, you have the right to sue the police. If you are a United States citizen and you're living in Arizona and the police do something that is objectionable, you can sue them. And that right never existed nationally prior to this ruling, and none of these rulings could have been done without the passage of the 14th Amendment. And I just restate that here at the end. The national government has no right to make any of these rulings minus the 14th Amendment. You add the 14th Amendment in, and then the federal government, the national government, can get involved in this conversation. One of the more confusing issues related to federalism is the right to privacy. Um, Constitution itself does not actually contain any use of the phrase right of privacy. A lot of people think the Bill of Rights contains right of privacy conversation, but it does not. In fact, the Bill of Rights actually contains several examples of times when the government can actually invade your right of privacy. uh, through search and seizure and different things like that. And so the founding fathers, they didn't actually put privacy in the Constitution itself. And so a good question is, why did the founding fathers not guarantee the right of privacy? I think one answer to that would be that the founding fathers tried to be very careful with their words. And you can see how, from our own study, the words necessary and proper and general welfare have been misconstrued to mean something very different from what the founding fathers were using those words to mean. And so that's probably a good reason why they did not use right of privacy in the Constitution itself. And then we should also consider when we talk about privacy issues, the many potential conflicts that exist between the privacy of one person and the freedom of another. I mean, the truth is, if we would get any group of people together and ask them what they believe to actually define what they believe right of privacy to mean for them, we're going to get a lot of different answers. And we're also going to come into the reality that there are lots of conflicts that exist whenever we talk about privacy of one person and how that would affect the freedom and well-being of another person. And so it's a very complicated issue to understand, but a very important issue, certainly in the development of American political conversation. So, the way this hashed itself out in our country and how now we do have a right of privacy is again through the court system, through the Supreme Court. And remember, the courts are supposed to interpret law. The legislative branch makes the law, the executive branch enforces the law. The courts are there to interpret the law. What we're starting to see is as we get to this fourth section of the course and then the next two is that we're seeing a Supreme Court that's decided to go far beyond simple interpretation of law and to begin to actually make law. That's another very contemporary question about our government. And in Griswold versus Connecticut, maybe one of the most striking examples of the court jumping past interpretation of law and deciding to make a law. And it's a very important state national issue and again related to the 14th Amendment. So, what was going on? In Connecticut, there was a law that said you are not allowed to use or sell contraceptives. Now, you might sit there and think, well, that's sort of a ridiculous law. It was still on the books in the 1960s, but the truth is there is a historic and even contemporary example of folks thinking that you shouldn't do that. And as a result of that, there were laws passed, and Connecticut had a law. Now, people haven't really thought much about it, and there's all kinds of laws on the books that have become obsolete in many places, but this law was still in existence, and the Planned Parenthood opened up a branch in Connecticut, and they violated this law, and they were fined. And so they sued the head of Planned Parenthood in Connecticut. His name was Griswold. Sued the state of Connecticut in federal court, saying basically that this law was unconstitutional. The court heard the decision or heard the case and overturned Connecticut's law that prohibited the sale and use of contraceptives. Now, that in and of itself is a minor issue. The bigger issue is what was the basis of the court, the National Supreme Court, saying to the state of Connecticut, we're going to get rid of one of your laws. How could they do such a thing? And they said this, that their ruling was based on what they called the fundamental right of privacy. The court said, even though the words are not in the Constitution, that privacy was a penumbra. Look at that word, penumbra. A penumbra right in the Bill of Rights. Now, penumbra is the area between the light and the shadow. If you see your shadow and you see the light surrounding it, there's this kind of undefined area in between. That's what a penumbra is. And the Supreme Court said that basically it's not written there, but it's there. Now, just think about the can of worms that this opens up. You know, one of the things that law is based on is words, words that you can see, sentences that you can read, things that you can define. What this says, this ruling says is, yes, it's not there, but it's there. It's not there, but it's meant to be there. It's a penumbra. It's in between the light and the darkness. And it's that gray area and it's there. And so they overturned this Connecticut law based on a right of privacy in the Bill of Rights. And why does this matter on the national level? Because the 14th Amendment now. So the national government, this is the best example I can give of you, is coming into Connecticut and saying, you're violating the rights of U.S. citizens by telling them they can't use or sell contraceptives. And so we're going to overturn your law to protect the American citizens that live in Connecticut so that they have their right of privacy. However, the right of privacy is not exactly written in the Constitution itself. Interesting. More interesting because the probably one of the most controversial of all court cases in American history, the Roe Wade case, the abortion case of 1973, comes out of this Griswold, Connecticut discussion. In the Roe Wade case, what happened was a woman, her name was not Roe, was living in the state of Texas. They named her Jane Roe, like a John Doe, anonymous name. She wanted to have an abortion. She was pregnant, wanted to have an abortion, but the state of Texas said, the law in Texas said that she couldn't. It was illegal to have an abortion in Texas. At this time, some states allowed abortion and some did not. In Texas, they did not allow it. The court, Supreme Court, Jane Roe, she sued the state of Texas. The attorney general's name was Wade, so that's how his name showed up in here. She sued the state of Texas, um, saying that she had a constitutional right to privacy and that this was a private decision about her own body. The court overturned the Texas law banning abortions in that state. They agreed with Jane Roe, and they based their ruling on the right of privacy that they had established previously in the Griswold case. The result of this ruling was gigantic. It resulted in abortion being legal everywhere in America anytime before what the court called viability. They did not define exactly when viability occurs, so we can see that that's been controversial as well. And the court refused to deal with the question of when life begins. So what the court did was, and again, this is what happens when we get into vague conversations and make laws or decisions that are not based on words, but start to create words. So now a right of privacy that was not in the Constitution, but that they created from it, leads us to make a major moral decision that the American people are by no means, even today, in consensus on what to do about this question. But what happened was a situation in which the people of a state could decide for themselves what to do about this issue was taken away by Roe Wade. You might hear many of the presidential candidates saying, well, I believe in overturning Roe Wade. That doesn't mean they believe in making abortion illegal throughout the United States. That just means they believe having the question put back to the states. So Texas could write another law, or Pennsylvania could write another law, but New York could make abortion legal, and there wouldn't be anything. They, many people believe that it's just a state issue, that the national government really should not be involved in this question. But what's happened is the Supreme Court, in a 5-4 ruling, 5-4, decided that no state, no state could regulate abortion before viability, and but they didn't then define what viability meant. It's created lots of confusion since, lots of questions about late term abortions now, and all kinds of things like that. But the point here is this: is that I want you to see the connections backwards. Roe Wade to Griswold versus Connecticut and the right to privacy to the 14th Amendment. That's the progression I want you to see and understand in this conversation. And begin to ask yourself this question: should the national government uh, be involved in questions like this, deciding major moral issues for the country? Again, under the Constitution originally, the answer to that question would be absolutely not. The founding fathers had lots of good, solid reasons for that. We have changed that. We have gone in a totally different direction as a result of the 14th Amendment. And as a result of that, we have these confusing questions that people might see a lot of different ways. But I challenge you to think about it and think how you see it. And don't look at it through the lens of pro life or pro choice, because once we do that, we stop thinking. Look at it through the lens of what do you think the government should and should not be doing for us to have the best country that we possibly could have. Complications regarding right of privacy, just to throw out a last kind of thought here to you, uh, goes way beyond abortion. What about viewing pornography in your home? Does the federal government have a right to say something about that? What about using drugs in your home? What about employer grooming and dress regulation, monitoring your emails and drug testing? What about terminating life sustaining medical treatment? What if you don't want can the government force you to get medical treatment to sustain your life? What about using facial recognition in airports and sporting events? What about stores tracking your purchases with your debit or credit cards? What about Google tracking where you go on the internet? Where do you want the government to be in all of this conversation? Some complicated stuff, not easy stuff to think about, but important stuff to think about.